Can a mother write a perfectly signed will and yet the court still refuses to accept it? This real case will shock you. Imagine a family with 4 children, and imagine the mother writes a will, properly signed, properly witnessed, but gives her property only to 3 of them. The fourth child, Victor, is completely left out. Not a line, not a reason, just silence. That silence became the storm. This is the story of Lilian Coelho versus Mayra Filomena Coelho, decided by the Supreme Court on the 2nd of January 2025. When the mother passed away, her daughter Mayra took the will to court. It said that the 2 sons, George and Reginald, and Mayra would share everything equally. But Victor, the son who got nothing, said, "This doesn't feel right. Something is wrong with this will." The first judge agreed partly. The signatures were proper. The mother knew what she was doing. But the judge also saw suspicious circumstances around the will. And Mayra couldn't clear those doubts, so the judge refused to act on the will. Mayra appealed. The next court said, once a will is properly signed, we should not talk about suspicion. And they accepted the will. But the Supreme Court stepped in and said, no, that is not how the law works. A will may be perfectly signed and still feel unnatural. A will may follow all the rules and still look doubtful. And when a son is suddenly cut out, the court must ask why. So the Supreme Court set aside the second decision and sent the case back for a fresh look. Because a will should not only be valid on paper, it must also feel genuine in the heart of justice. If you want more real stories explained in simple language, subscribe for more. Thank you for watching.